Pleases the court, I am Weeding initial S and I appear with my learned junior counsel, Cell initial S, for the defendant, Juniper Point Eatery. Your Honour, negligence gives individuals the right to pursue personal injury, consequential psychological injury, or economic loss that may have been suffered due to an act or omission of an individual or individuals who have failed to take reasonable precautions against foreseeable risks. Before this court, the plaintiff has claimed that negligence by the defendant has resulted in his personal injury and consequential psychological injury. Counsel for the defendant refutes this claim on the basis of 4 submissions. Submission 1, that the defendant does not owe a higher standard of care on the basis of the occupier of the premises and entrant. Submission 2, that the defendant did not breach his duty of care on the basis that if he failed to provide a security guard on the day in question. Submission 3, on the balance of probabilities, the plaintiff has not established a link of causation between the defendant's imposed duty of care and the subsequent injuries incurred. Submission 4, the plaintiff's consequential mental harm was not caused by any duty of care that the defendant held towards the patrons of the Juniper Point Eatery. I will now move on to submission 1, that the defendant does not owe a higher standard of care. Counsel for the defendant does not dispute the fact that a duty of care is owed to the plaintiff. However, as the relationship is one of occupier and entrant, it is a general duty of care. The 2000 Court of Appeal case Modbury Triangle and Ansell found that the occupier of the premises does not owe a higher standard of care where a special relationship between the parties does not exist. The plaintiff may argue that there is a standard of care to protect patrons from criminal conduct of third parties, as in the 2009 Court of Appeal case Adil's Palace Pty Ltd and Morbrak. However, in this case, Justice Giles held that it was not the defendant's status of occupier that gives rise to the duty, but rather the foreseeability of injury from conduct on the premises plus the capacity to control the conduct. It was unforeseeable that the attacker would return to the premises and attack the plaintiff. This was out of the defendant's capacity to control. In the alternative, counsel for the defendant argued that the defendant did take reasonable measures to control rowdy and intoxicated patrons from criminally injuring other patrons by removing them from the premises. In the 2007 Court of Appeal case Wagstaff and Haslam, Justice Baston held that the basis of duty must be found in the level of control exercised by the occupier over the premises and the occupier's knowledge or ability to know about the condition of persons on the premises where liquor is being sold. The defendant exercised control by asking the patrons to leave, and therefore had no knowledge of any of them still posing a threat to the plaintiff. Submission 2. The defendant did not breach its duty of care by failing to provide a security guard on the day in question. Under Section 9, subsection 1A of the Civil Liability Act 2003, a person does not breach a duty to take precautions against a risk of harm unless the risk was foreseeable. That is, it is a risk of which the person knew or ought reasonably to have known. In the 2009 Court of Appeal case Adil's Palace Pty Ltd and Morbrak, Justice Campbell held that the previous incidents at the club, as well as the inherent probabilities of the type of activity being carried out in the club, made it reasonably foreseeable that the patrons would include potentially violent and troublesome ones. The Juniper Eatery had no history of any incidents occurring. In addition, the time the incident occurred, approximately between 2 p.m. and 3 p.m., the atmosphere was relaxed, and majority of the patrons consisted of local families, indicating a family environment. The type of activity being carried out was meal service, possible drinking, and open mic entertainment. This venue was not a nightclub, nor was it foreseeable to have a security guard on to prevent incidents occurring during the day. It was held in the 2007 Court of Appeal case of Wagstaff and Haslam by Justice Studdert and not challenged by the appeal judges that they were not negligent in not having adequate security on duty at the time of the altercation, as the plaintiff had not brought sufficient evidence to suggest unreasonableness according to current industry practice. The circumstances surrounding this claim do not suggest any unreasonableness according to current industry practice. According to Section 142 AG, subsection 1AI of the Liquor Act 1992, it is a condition of the licensee's license that the licensee must ensure that at least the required number of crowd controllers are engaged in maintaining order in and around the licensed premises while the premises are open for business after 11 p.m. The altercation at Juniper Point Eatery occurred between 2 and 3 p.m. Therefore, was no obligation under current industry practice to have security guard on the premises. If it pleases the court, my learned junior will now address submissions 3 and 4.